This is the module on venue in the great world of civil procedure. Now, I often get this question, and it's a great question. What's the difference between subject matter jurisdiction and venue? Well, subject matter jurisdiction tells us that we can go to federal court. Certain cases invoke federal subject matter jurisdiction. Venue tells us exactly which federal court we go to. So there are 94 federal districts in the United States, and we want to lay venue in an appropriate district. So subject matter jurisdiction just said, hey, okay, go to federal court, but it didn't tell us which one of those 94 districts to go to. That is what venue tells us. We're going to do 3 sections in this module. Section A, the general rules. Section B will be transfer of venue. And Section C, forum non-convenience. Now, let's start off Section A, the basic rules. And you will find the plaintiff's choices in Section 1391, B1, and B2. The basic choices available to the plaintiff when the plaintiff sues in federal court is to lay venue in a district under 1391 B1, B, or B2. Now, those 2 subsections give the plaintiff 2 choices. First, you may lay venue in any district where all defendants reside. Any district where all defendants reside. Now, notice something about that. All of the defendants must reside in that district for this to work. So if we had 2 defendants, one resided in the Southern District of California and the other resides in the Northern District of Iowa, you may not use either of those. Neither of those is proper because it's got to be a district where all defendants reside. But there's a great sub-rule that we must know. And the sub-rule is this. If all defendants reside in the forum state, if all defendants reside in the forum state, the state where this case was filed in federal court, then we may lay venue where any one of them resides. If all defendants reside in the forum state, we may lay venue where one of them resides. So, let's say we had 2 defendants. One resides in the Southern District of California. The other resides in the Northern District of California. There is no district where all defendants reside, but they reside in the forum state. And so we can sue them both either in the Southern District of California or the Northern District of California. We could not sue them in the other districts in California, like the Eastern District or the Central District. It's got to be a district where one of those defendants resides. So when all the defendants reside in that forum state, we have that great rule. You can sue them all in a district where one of them resides. Now, notice that word resides. What does that mean? Resides is different from citizenship, isn't it? Citizenship was relevant for subject matter jurisdiction, diversity of citizenship jurisdiction. What does resides mean? Well, luckily, resides is defined by statute. It is defined by the statute. And for a human being, your residence is the district in which you are domiciled. District in which you are domiciled. Now, what does that mean? That means there's only one district where you reside because human beings, as we know, only have one domicile at a time. So a human is going to reside in the district where domiciled. What about businesses? What about businesses? And I mean here any kind of business, not just a corporation, but a partnership, limited liability company, etc. And notice by statute, a business resides in all districts, where it is subject to personal jurisdiction, PJ, for this case. A business resides in all districts where it is subject to personal jurisdiction. We'll abbreviate it PJ for this case. Now, that means that a business might reside in several districts. It resides in every single district where it would be subject to PJ for this case. So that is one venue choice. The plaintiff may lay venue in a district where all defendants reside, and we saw some sub-rules about that. Now, the other choice is that the plaintiff may lay venue in any district where a substantial part of the claim arose. You may lay venue in any district where a substantial part of the claim arose. And that's great language because there might be more than one district. For example, maybe the contract was negotiated in one district and entered in another district and to be performed in another district. It's arguable that a substantial part of a breach of contract claim would have arisen maybe in any of those three. Now, those are your choices as the plaintiff. You are filing in federal court, and under 1391 B1, B2, you got two choices. Neither one of those is a preference. It's just totally up to you. It's an alternative. And you can lay venue either in any district where all defendants reside or any district where a substantial part of the claim arose. Now, notice something else. There is a section, 1391 B3, that seems to give you another choice. It seems to say that you can lay venue wherever there's personal jurisdiction over any defendant. Well, why wouldn't we always use that? Folks, do not go for that head fake because that part of the venue statute almost never applies. That part of the statute only applies when there is no district anywhere in the United States of America that will meet either of the two choices we just did. So if there is no district anywhere in the United States where all defendants reside or where a substantial part of the claim arose, then and only then can you go to that additional choice, which is called fallback venue. It almost never applies because it would only work if the claim arose 100% overseas and there's no district in this country where all defendants reside. So that's why we talked about the two basic choices for the plaintiff. Notice one other thing. These rules do not apply to cases removed from state court to federal court. These rules that we just did apply only when the plaintiff is filing initially in federal court. They do not apply in a case that's removed from state court to federal court. There, as we saw in removal jurisdiction, part of subject matter jurisdiction, that case could be removed only to the federal district that geographically embraced the state court where it was originally filed. So these rules, again, only apply when the plaintiff is filing initially in federal court. Now, we know where the proper venues are. Section B, let's talk about transfer of venue. Transfer must be within courts of the same judicial system. Since we're in federal court, we are talking about going from one federal district court to another federal district court. And because we are in the federal system, transfer can cross state lines. We can transfer from a federal court in the District of Maine to a federal court in the District of Hawaii. That's okay. You could never transfer from a state court in Maine to a state court in Hawaii because those are different judicial systems. And so when we're talking transfer in the federal system, we're going from one federal district court to another federal district court. Some terminology whenever we have transfer. Since we're going from one court to another court, both in the federal district system, here's our terminology. The original federal district is the transferor. It's the transferor. And the one to which we transfer is the transferee. The original federal district is the transferor. The one to which we send this case is the transferee. So we only get to transfer if the transferor court grants a motion to transfer and sends the case to the transferee court. Friends, there are two transfer statutes that we need to know about in the federal system: 1404A and 1406A. Now, obviously, there are important distinctions between them, but I want to start by talking about what they have in common. Under both of these statutes, under 1404A and 1406A, the transferee must be a proper venue and have PJ, personal jurisdiction, over the defendant. The transferee, the court to which we send it, must be a proper venue and must have personal jurisdiction over the defendant. And folks, those must be true without waiver by the defendant. Those two things must be true without waiver by the defendant. That's an old case called Hoffman versus Blasky. So if we're in the federal district in Maine and the defendant comes in and says, I want to transfer this case, order this case transferred to the federal district court for the District of Hawaii. And then the defendant says, look, there's no PJ over me in Hawaii and venue's not proper in Hawaii. Nonetheless, I'll waive those, transfer the case anyway. We cannot do it. We cannot do it. You can only transfer to a court that is a proper venue and has PJ over the defendant without waiver of those things by the defendant. Now, there is a very minor inroad on that. 1404 does say that you may transfer to any district at all, even an improper venue, if all the parties agree and the court thinks that transfer is a good idea. Folks, that is very, very minor because the plaintiff will never agree to that. Why would the plaintiff want to give up the forum in which she initially sued? So I wouldn't worry a lot about that minor inroad. We will go with the Hoffman rule. You can only transfer to a district that is a proper venue and has PJ. Notice why this is a great exam question. Not only do you have to know transfer, but you gotta know venue and you gotta know PJ. Those are testable in these hypos. Now, that's what 1404A and 1406A have in common. How do they differ? What's the difference? In 1404A, the transferor, the original federal district, is a proper venue. In 1404A, the transferor, the original federal district, is a proper venue. And under 1404A, that court may transfer to another district based on convenience of the parties and witnesses and based on the interests of justice. Now, that's pretty open-ended, based on convenience for parties and witnesses and the interests of justice. Now, what does that mean? Well, courts are very common sense here. And really what we're looking for is that the transferee just makes more sense than the present court. The present court is a proper venue. It's fine. It's good. But the other case makes more sense. What a lot of people say here is center of gravity. The other place is the center of gravity. That's where all the witnesses are. That's where all the events took place. Things like that. That would make more sense to litigate in that other district. Courts have enormous discretion in ruling on motions to transfer under 1404, and they generally look at a series of what they call public and private factors, to determine whether that other court, the transferee court, is the center of gravity. Public factors are things like, gee, which court ought to be burdened with this case? Or, gee, maybe it makes more sense to be there for the administration of justice because that state's law is going to apply anyway. Private factors are all about convenience. Where are the witnesses? Where's the evidence, etc. So we have a great deal of discretion under 1404 to grant transfer because the other place just makes more sense. Now, I want to flag a case called Atlantic Marine that came down in 2013. Atlantic Marine dealt with a forum selection clause. Now, these are pretty common. You and I enter a contract, and you're going to build something, and I'm going to buy it. And we may provide in that contract that if we have a dispute, the dispute must be litigated in a particular place. That's a forum selection clause. Most courts enforce them as long as they're not a product of overreaching. And in Atlantic Marine, the court said that a forum selection clause is a very, very, very important factor in ruling on a 1404A transfer. So in that case, there was a forum selection clause that said when these parties have a dispute, it'll be litigated in the Eastern District of Virginia. And then the plaintiff sued in the Western District of Texas. Defendant moves to transfer under 1404A. It was proper because the Eastern District of Virginia was a proper venue and had PJ over the defendant. And the court said that the existence of that forum selection clause is very persuasive. It shows that all the private factors do support transfer. So usually you will enforce a forum selection clause through a 1404 transfer when that statute applies. The other statute, 1406A, what's the difference? Well, 1406A applies when the transfer or the original federal court is an improper venue. In 1406A, the original federal court, the transferor, is an improper venue. Remember in 1404A, the original federal court was a proper venue. Here it's an improper venue. And 1406A gives the court a choice. It may transfer in the interest of justice, or it may dismiss. It may dismiss, and that makes sense because plaintiff sued in an improper venue, and that is a basis for dismissal. So that's the difference between those two statutes, but don't overlook what they have in common. Under both of those statutes, you can transfer only to a district that is a proper venue and has PJ over the defendant for this case. Section C, what about forum nonconveniens? Now, this is where a court dismisses a case because there is another court that makes a lot more sense. There's another court that is the center of gravity that just would be a lot more convenient. And here, we do not transfer, we dismiss. Now, that seems kind of harsh. Our normal reaction would be, well, why do you dismiss? Why don't you just transfer? Folks, here's the kicker. We dismiss because transfer is impossible. Now, why would transfer be impossible? It's impossible because that other court, the better court, the more convenient court, the center of gravity court, is in a different judicial system. And you cannot transfer to a different judicial system. What we're going to do, maybe, is dismiss under forum nonconveniens and let the plaintiff sue in that other place. This comes up very frequently where the center of gravity, more convenient court, is in a foreign country. Because obviously you cannot transfer to the court of a foreign country. So we might dismiss here in the United States and let them go litigate in the foreign country. The most famous example is Piper Aircraft versus Reno. Piper Aircraft versus Reno, 1981 Supreme Court case. It's in all the books. We had a plane crash in Scotland. Dreadful, dreadful accident. It killed all the passengers and the pilot, and they were all Scottish citizens. The plane was operated by a Scottish airline. It was owned by Scottish citizens, but the plane was manufactured in Pennsylvania. So there's a case against the manufacturer of the plane in the federal court in Pennsylvania. But the Supreme Court holds that that case should be dismissed under the doctrine of forum nonconveniens and let the plaintiff sue in Scotland. That litigation does not belong here. It ought to be sued upon in Scotland. Now, to make this decision, the court looks at exactly the same public and private factors that they look at in ruling on a 1404A transfer. In ruling on a forum nonconveniens motion, the court will look at exactly the same factors that it will look at in a 1404A transfer motion, public factors and private factors. And if you go back and look at the case, and it's in all the case books, take a look at footnote 6 of the Piper opinion. Footnote 6 is the classic list of the public and private factors, which we discussed in 1404A. Now, usually it requires a very, very, very strong showing to get a forum nonconveniens dismissal. Even a stronger showing than transfer, because this is so harsh. We're dismissing here. Transfer is a little less draconian. So you may have to make a stronger showing to get forum nonconveniens than you would for 1404A transfer, but they are the same general factors. Now, some other things about forum nonconveniens. It is crucial that the other court, that foreign court, be available and adequate. We are not going to dismiss a case in the United States if it leaves the plaintiff with no courtroom at all. So we only do this after we become convinced that the court in the foreign country, the court in that other place, is available and it is adequate. Now, adequate, however, does not mean that you're going to recover the same kind of remedies. Not at all. Adequate basically means that you, the plaintiff, are going to get a day in court. You're going to be heard. You're going to be heard. The fact that that foreign country may not give you a jury trial, may not allow recovery for pain and suffering, may not allow punitive damages, may not allow damages for emotional distress, that doesn't matter. That does not make it inadequate. So just so long as you'll get a day in court, the fact that you're only going to recover $1.98 in the foreign country does not make it inadequate. Now, one other thing, courts often impose conditions on a forum nonconveniens dismissal. Courts will quite frequently say, okay, defendant, I will grant your motion to dismiss for forum nonconveniens, but in exchange for that, you must waive certain defenses in the foreign country, like maybe waive statute of limitations or waive any kind of personal jurisdiction or other defense. And that is very, very common. And so we do that. That's absolutely fine, not a problem at all in a forum nonconveniens dismissal. So in this unit, we talked more about forum selection. We've already decided we're suing in the right state. That was personal jurisdiction. We've already decided that we're in the federal court system. That was subject matter jurisdiction. Here we learned about exactly which federal district in the federal system, that's venue. We might transfer from one federal district court to another federal district court. And if the center of gravity court, where this really ought to be litigated, is in a different judicial system, we might dismiss under forum nonconveniens. Folks, we've been at this module long enough. I think we need to dismiss on the basis of forum nonconveniens.